Welcome back to Wake Up with Nubian Tigers Talk, a podcast brought to you by a group of Black Princetonians, where we talk about issues impacting our Black communities. So this is our first episode since hiatus, Ray.
2022.
Hope you had a good holiday break and
Thank
got
you.
rested up.
Same to you.
Yeah. So Ray, tell us, we've been, there's been a lot of stuff happening in the courts around the issue of police and holding them accountable for killing Black people. So tell us what you have lined up for us today.
Well, we've got my dear friend from class of 78, Glennon Threet, who was a political science major at Princeton. And he's been down in the Birmingham area for many, many years practicing law. So we'd like to welcome him to our podcast. And as I said, he earned his graduate degree in political science from Princeton in 78, earned his law degree from Howard. I think you know a little bit about Howard in 1981. And through the years, he was admitted to the state bars of Colorado in 84, District of Columbia in 85, and the State Bar of Alabama in 1999, which is where he resides today as the senior litigator in the Office of the Federal Public Defender for the Northern District of Alabama in Birmingham. He's also a member of the Bar Association of the Supreme Court of the state of Alabama, the U.S. District Court for the Middle and Northern Districts of Alabama, and the District of Columbia Court of Appeals. And he is a former adjunct professor of trial advocacy at the Cumberland School of Law in Birmingham, Alabama.
So Ray, Glennon wanted us to remind people that he is speaking today in his personal capacity
Right.
and not in his role as a public defender. So
Important.
Yes.
But over his career, Glennon has practiced all kinds of law in the areas of state and federal criminal defense, immigration, family and domestic relations, civil litigation, and probate, which makes him an excellent guest for our podcast. Glennon, welcome to the show, brother.
Thank you, Ray, and thank you, Michelle.
So great to have you. We've been wanting to have a discussion about these trials that were going on for a long time. So we're so happy to have you here. So over the past year, there's been a number of high-profile criminal trials involving the death of Black people at the hands of the police or by vigilantes. And of course, here we're talking about the Derek Chauvin trial, the police officer who killed George Floyd. Kim Potter's verdict just came in over the death of Dante Wright. And we have the trials of the McMichaels and William Bryan for the death of Ahmaud Arbery. And at the same time, we have the Rittenhouse trial, which didn't turn out quite as people were expecting, I think. So let's start with the trial of Derek Chauvin. Many Black people thought his guilty verdict signaled that we had turned the corner on holding the police responsible or accountable for the deaths of Black people. So tell us your thoughts on the successful outcome of the trial and whether you think it portends anything for the future.
I'm not so sure that I consider it a success. I think what it portends for the future is that if you have overwhelming evidence and you have the right time period, then you can get a conviction. But if you look what it took to get a jury to convict a police officer in the George Floyd case, I mean, there was a video that was recorded by multiple people of a person engaged in probably some of the most egregious conduct that was ever recorded on video. And it took all of that to get an officer convicted. And so I don't know that absent that sort of video evidence, it would be so successful going forward. So I can't say that that'll be replicated going forward.
Yeah, and I've wondered myself whether or not the success of that trial actually will make it harder to get prosecutions of police officers in the future if we don't have that level of expertise on the prosecution team. And as you say, the overwhelming evidence against the police officer.
Until we started having video from pocket video from cell phones and stuff, it was very difficult for us to even get many of these issues to come to light. And so what I think the Chauvin case is, it raised the bar so high for the level of evidence that's necessary in order for a police officer to be convicted. Because what we've got to remember is that police officers have something called limited
immunity.
Yeah. That immunity makes them judged by a different standard than an ordinary person. If they have any reasonable reason to believe that their life is in danger, they can use deadly force. And so that standard of liability is very, very different. And so that's one thing that we really need to change in order to see these cases take a major step forward.
I'm going to get back to that standard of reasonableness a little bit later after we go through the trials, because this is an issue when I'm teaching criminal law that I have talked about repeatedly our concepts of what reasonable use of force is in response to threat and so forth. But we'll get back to that. Dr. Chovin and the 3 officers who haven't been actually tried yet for the criminal charges, for the murder charges against Floyd, are also being prosecuted for federal civil rights violations.
That's correct.
So I'm wondering if you could explain to our listening audience what the difference between the 2 trials would be, and why are we having 2 different cases against them?
Well, the major difference is that the standard of proof in a civil case, which is a civil rights case, is proof to a preponderance of evidence. In a criminal case, it's beyond a reasonable doubt. And so the level of evidence that's necessary to find them guilty or responsible in the civil case is lower than to find them guilty in the criminal case. That's the major difference. The other thing is that in the civil case, they could be fined, they won't go to jail.
So give us some examples in your career, Glenn, that you've been exposed to in terms of civil case versus a criminal case.
Well, the biggest example I can think of is, trying to think of the guy from California.
Rodney King.
Rodney King, he was found, they were found not guilty in the criminal case and they were found responsible in the civil case. Same thing happened in O.J. Simpson. He was found not guilty in the criminal case and found responsible in the civil case. So because the standard of evidence is different. But, it's a different jury selection process. What happened in George Floyd's case, the family had already been paid $27 million before Chovin even went to trial.
Right, exactly. And as you look at that case, though, I mean, based on how the Floyd case went, what do you think the chances of convicting in the civil case the other 3 officers that were part of the George Floyd murder?
I think they'll all be convicted. I think everybody involved in that case is going to be convicted. Well, Chauvin's already pled guilty. And so he will probably can testify against him, or he testified to a statement of facts that will implicate them, and nobody's going to walk away from that case now.
All right, so let's switch and look at the case with the young man Dante Wright, who was killed by the police officer Kim Potter. She tried to defend her actions by saying she meant to hit him with her taser, and I mean, everybody that was involved in the case or watched the case, your gun is on one hip, your taser is on another. So that's a hell of an accident to make with somebody. But she was eventually charged with manslaughter and not murder. So do us a favor for our listeners. Can you explain what the manslaughter charge is based on?
The major difference between manslaughter and murder is that murder is a homicide with the intent to kill. You have to prove that there was an intent to take someone's life, not an intent to harm them, but an intent to end their life. Manslaughter is usually the 2 most common types of manslaughter are heat of passion manslaughter, which is somebody comes home and finds their loved one, finds their spouse in bed with another person, and they commit a murder in the heat of passion without really thinking about it. Or either reckless manslaughter, like the football player that hit the person in the car that was drunk out in Nevada.
Right.
Where they're just negligent and reckless. Right. But in this case, the jury found that she was guilty of first-degree manslaughter because she caused his death with recklessly handling the firearm in a way that death or great bodily harm was reasonably foreseeable. And the problem with this woman is that this is a 26-year police officer that had no previous complaints. She was a training officer. In fact, she was training someone that day. She didn't even really have to get involved in the arrest.
He was already under control by another police officer when she went to go get what was supposed to be her taser.
She didn't need to tase him anyway. What she said is that he was going back in the car and she didn't know what he was going back to get. But her actions were completely unjustified. She acted recklessly and it resulted in his death. And one thing about the jury deliberations, and we know a little bit more about that case than we know about the Chovin jury, because Potter, the jury, talked to the press.
Right.
A couple of the jurors said in Potter is that they handled the taser and they handled the firearm, and they said after handling it, there was no way it could have happened accidentally.
Now,
they just go ahead.
No, finish.
They're different weights. A taser and a firearm don't feel the same. Not to a person that's been wearing them every day for 26 years.
Exactly. And it's supposed to be a trainer. But here's the interesting thing in that case. She testified in her own defense, Glennon. What did you think about that? Was that a mistake on her part? Was that just arrogance on her and the defense attorney's part? But I mean, would you recommend that for a person in that situation?
I have been practicing criminal defense law for 37 years. The only time I put a defendant on the witness stand is if he made me, or if I felt we could not win the case without him. It's almost always a mistake, because when the defendant takes the witness stand, he or she becomes the only witness that matters, because if they don't believe you, then they don't need any other evidence.
But it's also interesting because in the, not necessarily in the way we look at criminal law, but the way we look at the way racial attitudes play out, white women traditionally will use tears as a way to divert attention from the wrongness of their behavior.
Their culpability.
Right. So when she got on the stand and started crying, I was thinking, that's it exactly, right? That's the default position for absolving white women of responsibility for what they do. Let them cry, show emotion, show that they are human beings who are just capable of quote unquote.
And she probably thought it would work with the makeup of the jury.
Well,
it did work. It did work.
Yeah.
When you look at the jurors' comments, what they say is that they don't believe that she intended to kill him, but they believe that she needs to be held accountable for her actions.
Right.
And that's why you heard Keith Ellison say this was accountability, not justice.
Right.
Because it is not justice. It's not justice at all. She could end up with a sentence of less than 10 years.
Yeah.
And the guideline sentence for her is 7.5 years. And we got people down here to get more time than that for stealing out of a Walmart.
Exactly. And it's also interesting because it just in the news recently, this obviously this episode is going to play, we're recording on Martin Luther King Day, but it's going to play sometime later. But just this week, they released news that the police officer who killed Laquan McDonald is already going to be released in February. So he's actually served 3 years for
that was a Chicago case where the man was shot 16 times.
Yes.
Yeah, that was an atrocious case. That was a case that they hid for years.
Yeah, and they hid the video, and Rahm Emanuel tried to prevent the disclosure of the fact that the video was available and showed that they in fact had murdered Laquan McDonald. So you're right. Her sentence, her eventual sentence, may not be very long at all, and whatever it is, she's not going to serve the full length of it.
Oh no, they'll wait until it's no longer publicly a hot topic anymore, and then they'll let her come out of jail or come out of some home detention or early release program.
Yeah.
Well, we've got innocent Black men that serve 30 and 40 years in prison for crimes they never even committed.
Exactly.
And the thing about that, just to go on a tangent, give me a second, Michelle. What kills me is like front page New York Times, Washington Post, some Black person that was incarcerated for 30 something years, they want like credit for it because they're letting them out, because they were unjustly convicted. How is that person supposed to get 3 or 4 decades of their life back? What kind of life?
They didn't give them anything back, and they don't want to hold accountable the people who put them there. Like in Emmett Till's case, they should hold that white woman accountable for lying, especially after she admitted it.
Exactly right.
They didn't even want to put her name in the paper because they were afraid that someone would shame her. She lived 40, 50 years of her life knowing that somebody was dead because of a lie.
Yeah, right.
Okay, thank you for letting me rant, Michelle. You go.
No, it's so true. And if we look at the number of police killings that we've had, yes, we have these 2 well-publicized verdicts against police officers. But if you look at the number of people who were killed just in the period around George Floyd's death, or the year before it and the year after it, very few of the police officers who have been involved in those shootings have been charged, right? Elijah McCain, yes, his family settled with the police, but no police officer was put on charge, arrested. Tatiana Jefferson, where they shot into the window of her home, no police officer was prosecuted for that. And Breonna Taylor, for God's sake, we still don't have any prosecutions in that.
We probably won't, and we probably won't get any.
Right, and we probably won't. So it's yes, these 2 cases got some accountability, but they're not a marker, in my opinion anyway, for progress of holding police accountable. So Glennon, what's your thoughts on that?
The Breonna Taylor case is so fact specific that it's hard to compare it to the others, because that's one where the police were executing a warrant at a place where there actually was somebody there that had been involved in criminal activity, and they shot in there. And he actually, I think if I remember the facts in that case, her boyfriend actually fired first.
Well, he did, because the police came in without the knock, as you know, with the no-knock warrant, and in plain clothes. Now, as it turns out, the information in the affidavit that supported the no-knock search warrant was falsified. And the officer who falsified that information is now facing disciplinary charges. But there wasn't anyone who was actually involved in a criminal matter at that location, and the police knew it before they executed the warrant.
But the problem with the law, and again, as we get back to the law being completely unfair inherently, is that officers are absolved from responsibility for executing a warrant that's based on false information if they don't know it.
Right, that's correct. Good faith exception.
Yeah, so it's just that makes me sick.
Yeah.
Cases like that fairly frequently.
And also the contradiction, right? That the one police officer was arrested for recklessly shooting into the neighbors.
Yes, not into the fact that Breonna Taylor was in bed, shot multiple times while she was in bed in her place.
Yes, but this also goes back to the issue of the reasonableness of the police behavior, which we're gonna get to.
And the dehumanization of Black people, because they look at her as collateral damage and not a person.
Exactly right. Exactly right. There's a kid in New York who was shot to death by a police officer responding to a mental health wellness call. And the police officer, he was inside his apartment in his kitchen holding a knife, and the police officer shot him to death. He was the person that they were checking wellness on.
Now you're getting ready to get to an issue that really makes me sick. I mean, you know, I don't know how that happens. I just don't know how it happens.
Yeah, but on the collateral damage issue, where they have tape where the police are, the supervisor is calling her and asking her, was anyone injured? And she says, no, just the perp.
Yeah.
Not a human being.
Well, yes. He was a perp before he was a human being.
Right. So it's just so fascinating. The whole issue of how the police kill mentally ill people is that could be a show in and of itself.
Right.
But before we get diverted to that, let's come to, as I call it, the tale of two cities, which are the treatment of the two vigilante killings that were also featured in public trials. That is the killing of Ahmaud Arbery in Georgia, and the killing that Kyle Rittenhouse committed in Kenosha, Wisconsin. Now, of course, the Kenosha, Wisconsin piece is connected because he went there in response to Black Lives Matter protests, although it wasn't two Black people that he killed there. So first, before we get into the details of the thing, can you tell us a little bit about vigilantism and how that has worked in American history?
You know, I didn't realize that the historical antecedents for vigilantism go all the way back to the Bible. But in the United States, the most egregious example of vigilantism to me is the history of lynchings in the South. I mean, I've had the opportunity to visit the National Memorial for Peace and Justice in Montgomery, Alabama. Have y'all ever been there?
No, but it's on my list.
I'm going to tell you, it moved me to tears. I got so angry that I actually walked out of the memorial in anger because I was looking at one of the exhibits, and it said a Black man had been lynched in a county in Alabama for annoying a white woman. And a white woman behind me made a comment about it, and I looked at her and left the memorial. But it represents 4,400 Black men between, I think, 1877 and 1950 that were lynched by vigilante justice. And vigilante justice was essentially a way for white people to take the law into their own hands and kill Black people that did things they didn't like. That's the easiest way to explain it in common terms. But basically what it means is that it's a mechanism that allows citizens to take over the enforcement of law when the law is not doing its job. But what it's turned into now is when they believe that the law is not doing the job the way they think it should be doing.
Yeah, I haven't been to the exhibit yet, but I hope to get to it if COVID ever settles down.
It's actually an outdoor exhibit.
Oh, is it? Okay.
It's outdoor.
Yeah, you got to travel to get there, you're right.
You do.
So that's not a thing. But I hope the exhibit, I don't know if you recall from when you were there, but I hope it also has some markers for some of the Black women who were lynched during that period of time.
It does.
Okay, good. So Travis McMichael and his son Gregory McMichael and their friend William Bryan decided that they didn't like the fact that Ahmaud Arbery was jogging in their neighborhood, and they made that decision that this was a Black man whose life was going to be ended that day. Interestingly enough, Travis McMichael also testified during that trial and talked about his fear of Ahmaud Arbery. Although the testimony seemed a little contradictory because at one point he said he wasn't afraid.
He couldn't say he was afraid because he's a white man.
Right.
His own supremacy killed him. And his own white entitlement made him take the witness stand because he thought that people would believe him in face of overwhelming evidence. I mean, once again, this is one of those situations where the evidence was so overwhelming, they had to convict him. I knew they were going to be convicted. The sad thing about the Ahmaud Arbery case is that they never would have gone to trial. They never would have even been prosecuted if Brian hadn't given up the tape.
Yep.
Right.
Because they didn't even arrest him that day. I think it was weeks later.
Weeks later. And the
they went through two prosecutors. They went through two different prosecutors.
Right. Because the original prosecutor worked with one of the defendants, or one of the defendants had worked.
The original prosecutor told them to go home and wash their hands and wash their clothes.
Yep.
Right. How about that for obstruction of justice?
Yeah, from a prosecutor.
Why didn't they get charged with conspiracy?
So it could be conspiracy, but
charged with obstruction
because you had to be part of the agreement beforehand. But for sure, she was charged with. She wasn't. I think she was charged with obstruction of a police investigation.
That's right.
Yeah. So she's currently awaiting trial. Although I doubt that case will go to trial. I don't see why she would take the risk. She should just get some plea deal going.
But getting back to the concept of vigilante justice, Michelle, the problem with vigilante justice is that there's no temperance in terms of sentencing. One of the worst aspects of the American criminal justice system is that Black people tend to get prosecuted more frequently than whites for the same offenses. And then when they get prosecuted and convicted, they get much more severe penalties than white people get for the same offense. So Black people like George Floyd got the death penalty for having a $20 counterfeit bill. Ahmaud Arbery got the death penalty for an alleged burglary or an alleged trespass. So we get the death penalty for anything we do that white people don't like.
Yep.
No, that's absolutely right. And they get taken into custody without incident.
That's correct.
Right. So coming back to the two trials. So the getting on the stand didn't work for Travis McMichael, but it did work for Kyle Rittenhouse, right? He got on the stand. He talked about being afraid. He started crying. He did all the traditional
That's
things.
not why he was found not guilty.
Okay, tell us why he was found not guilty.
The reason he was found not guilty is because there was video showing one guy with a gun in the second incident. And in the first incident, they believed that the guy had threatened him before he got on camera.
Right. They had video of one of the people, I think, that was either shot or that he killed, actually running toward him to try to get him to give up his rifle.
The guy admitted it when he testified.
He did.
The third victim didn't die.
Yeah.
And then the victim who did not die testified that someone shot at Cal before he killed that second person.
Right.
That's why he got found not guilty on that part of the crime, because they're actually two separate incidents.
So what signal does that send to us?
It sends a signal that people that violently respond to Black and progressive protesters can kill with impunity. That's what it sends to me.
And they can come from out of state.
Yeah. They counter protesters. And interestingly enough, the guy that gave him the gun did get convicted.
A misdemeanor, though. He only got a misdemeanor.
Convicted for having it.
Yeah, you can have it, but if you give it to somebody and they shoot somebody, okay, that's okay. So it's definitely interesting. And in our private conversations, or maybe it's on the video link I saw when you did an interview on this issue, you worried about a possible increase in vigilantism in response to Black lives.
I think we're already seeing it.
Yeah.
Because January 6th is a perfect example.
Yes.
Now what people say is that it just didn't happen. First, you had the people storming the governor's building in Michigan. They did nothing about that. Now they just deny that it happened.
Right.
Even though there's videotape of it in every place in the world, they just say it didn't happen.
Yeah, and you see this increase, for example, in the use of automobiles as weapons during protests.
The Charlottesville, Virginia incident.
Yeah, although that guy eventually did get convicted of murder.
Or tear gas in Lafayette Square.
And then you had the governor in Florida who tried to immunize people who would drive into crowds of protesters if they injured or killed anybody.
I think, unfortunately, that the distance between where we are now and Tiananmen Square is not as far as people think.
Yes.
Mm.
Right. No, I mean, and that's so clear too, if you also look at the attempts to regulate what we can read and talk about,
That's
right?
correct.
If you're talking about the evil of a communist society, we're there. we're now telling people, here are the 10 things you can't talk about. Here are the books you can't read. If the government says this is not good, you can't do it, right? So what's the difference between what we're doing and what we allege China is doing to those people in Hong Kong, for example?
Well, the difference is that
Um,
we have programs like this podcast that you and Ray are putting on, Michelle, that allows for
Yes,
that.
I hope that's going to make a difference.
That's the
But
difference.
you know, to the people who, to these far right people, I mean, they'll talk about how the evils of communism, and then they will turn around and engage in the same practices,
Yeah.
either without the awareness that they're engaging in the same thing, or because they don't care. So
They don't understand what communism really is.
well, that might be.
What they understand is a targeted propaganda that's being sent to them through social media.
Yeah.
And I think that progressives and certainly our government have understated the power of social media for far too long.
Far too long.
They allowed the far right extremists to use it to organize and commit violence, prepare themselves for violence.
And as you say, January 6th is a perfect example of that. And in your estimation, just to kind of go to January 6th a little bit, what do you think is the ultimate outcome? I mean, there was a report that I read that about the sedition conspiracy charges not being, given to any of the minor people that had committed offenses. But now that it's now been levied against the Oath Keepers, people think now that things are really going to change. Do you see that? Do you anticipate that?
No, I don't. I see Democrats losing control of the House in 2022. And if that happens, I think and if we get a new attorney general or people lose their heart for it, I think that those prosecutions down the line. The 700 people that are in the process are going to get misdemeanors and low-level felonies. Very few of them will get jail time, but I don't think they're going to go up the train. It's going to die.
Yeah.
Thank you for disappointing us.
I don't think any of the major organizers are going to get convicted and charged with felonies.
And I don't think it's a disappointment. I think it's a reality check on what liberals think the criminal justice system can do. And we're already seeing an example of that with the new governor in Virginia. He was just sworn in. The person he's named as the new attorney general has eliminated the conviction integrity unit. The entire unit was fired on Friday.
I applaud Merrick Garland for the 700 people that they've indicted. I really do, because it took a lot of nerve and a lot of guts to do that. That's the biggest prosecution.
But, it's also,
well, they're not done. They're not done.
But it's also an example of what can happen when a broader base of the community refuses to accept status quo, because many of those 600 people were identified by citizens. There's a whole left-wing unit that is dedicated to scouring the internet to identify people, and they've been successful in identifying two.
But let's face it, Michelle. I mean, so many of those people put their entering the Capitol on their social media sites. They made it easy.
Yeah, well, it's that, but see, there was the identity thing too. So yes, some of your stuff might be up on social media, but the identity of the people in the picture might not always be clear. And they have these civilian sleuths now who are just scouring everything to see if they can find out who are these people.
Getting back to your original question, and I guess sort of the theme of the show, to what extent do I think these recent occurrences are going to have any long-term effect on the American criminal justice system? I think that George Floyd, that case, and the Dante Wright case, to some degree, restored people's confidence in some sense of basic fairness. That they realize that even if it takes overwhelming evidence, there is a set of conditions under which a white police officer can be held accountable for killing an unarmed Black man. And that is something that a lot of people had lost. Because I was at the point where I didn't know what it would take. Because I'd seen instances personally where it was clear that police officers were involved in a bad shooting and people just overlooked it. They didn't prosecute them at all. They had one of the biggest cases in my career was 3 police officers that got killed in their apartment in 2004, and there was a lot of controversy surrounding that case. I've been personally involved in cases where police officers were involved in shootings with unarmed Black men, and it's not an easy thing for the lawyers or the defendants or the police.
Right.
Nobody wants to be involved in those cases.
Yeah.
Let me just corruption all up and down the whole entire criminal justice system.
Right.
Let me get to the last question then, because I think it ties into this issue of why people aren't prosecuted. And that is that one of the ways that the police always absolve themselves of any kind of accountability is that they say that they had fear, that their lives were at risk of death or serious bodily injury by the actions of the defendant. And we can trace this all the way back to the Trayvon Martin case and earlier, where white people only have to say that they had reasonable fear of a Black person in order to succeed on the merits of whatever claim they're making that gave them the right to kill the person. And yet Black people don't have the same right to say that, or when they say that they were afraid of white police officers, no one believes that that is reasonable. So there's been some literature around the idea that our legal standard on reasonableness in self-defense cases actually creates a hole that Black people cannot climb out of, because it almost automatically gives white people a valid reasonableness defense when they kill somebody. So
it really does, Michelle. And as a professor, you would understand, because it's a very nuanced argument that many people don't get. But the standard is that it's a subjective standard by the police officer whether or not he or she is in reasonable fear. Not an objective standard, meaning would a reasonable person other than a police officer who was thinking that they were already racist when they arrived on the scene
exactly
want to kill somebody because they have a phone in their hand.
Right.
Police officer says, well, I was afraid. And if they believe him, then it's a clean shoot.
That's right.
Right.
It doesn't have to be objectively reasonable. It just has to be subjectively reasonable to that officer at that instant of time.
Right.
And they'd have to find that the officer lied under oath in order to find them guilty. And that's why these cops have been walking, because they haven't even been able to get them prosecuted.
Yep.
That's exactly right. And you're right. It's a nuance that lay people don't really understand, because they don't really they're not really knowledgeable about the inner workings of the law. But if we look at a lot of these stand your ground cases, etc., they work for white police officers and they work for white vigilantes, but they don't work for Black people. Right. Because no one believes that no one white believes that it's reasonable for a Black person to be afraid of a white person.
Well, people say, well, you should have had a prosecutor tell me once, you should try to put yourself in the officer's shoes. I said, I can't compare myself to being some white man who lives 50 miles outside of town, that's inherently racist, that comes into a Black community and wants to shoot the first Black person he sees that does anything wrong.
Exactly.
I can't put myself in that position.
Yeah.
Because that's what happens. These people are policed by people who are there to maintain order, not to maintain justice and peace.
Well, Glennon, that is a perfect point for us to pull this together.
You get brownie points, brother.
Yeah, that was beautiful. That was beautiful. I couldn't have scripted that better.
Absolutely.
Are there any final words you want to leave with our audience about this issue of the police and trials and so forth?
I've really enjoyed it. I think two things. One is that I hear people sometimes talk about trying to get out of jury service. I don't think Black people really understand how important it is that we serve on juries. When I walk in a trial and see 60 people on a panel and there are 5 or 6 Black people, I know that none of them are going to be on my jury. But you can always get out of jury service if you want to, but I think we should understand that it's one of the most important things you can do as a citizen next to voting. The second thing is that I think we need to remember that these people are our sons and daughters that are being killed by the police, and it's not going to stop unless we do something about it.
Amen to that. That's a perfect.
That's our family there.
It is, and it doesn't matter what the police said they do. No one in our family deserves to be executed on the street without the benefit of charge.
No, we need to show up for each other, and we need to show up for ourselves.
Yeah.
That's correct.
Thank you so much, Glenn, and that
beautiful,
was
man.
Perfect and beautiful. Thank you for coming on the show. And hey, we might have you come back.
When you want me to come back, I'll be glad to come back.
No, I know we'll have you back, brother. Take care, Glenn.
You too.
If you enjoyed what you heard today, visit our website, NubianTigersPodcast.com. In addition to the podcast, we also post a resource page for each subject to provide additional sources of information. Follow us on Twitter. Our handle is @Nubian Tigers, written as one word. We're also on YouTube on the Nubian Tigers podcast channel. Our podcast is hosted by Anchor FM, but if you have a favorite podcast app, we're probably on it. Just look for the Nubian Tigers Talk. Looking forward to sharing some knowledge with you next time.
Wake up, wake up, wake up.